crack on. I'll pass over to Phil, who'll be dealing with the first half of the webinar. So,
yes, hello. So we're going to divide this in two, and the goal is that we'll each talk for about 45 minutes. And then, we can, after that, have them for discussions. I think that's right, Michael. You don't think we should do discussions one after the other? I think we'll do everything. You can put questions in chat if you want to ask things as we go along. So I'm going to be dealing with disrepair in general and with the fitness for human habitation provisions. And the paper, it hasn't been drafted by me, it's been drafted by my colleague Martin Hodgson, and it sort of deals with a whole range of practical issues that may come up in these claims. After that, Michael will tackle environmental protection prosecutions. He's had lots of experience of EPA prosecutions, and so we'll have these two sides, first me, then him. So if I then turn to my bit, and there's no particular sequence or order to the issues that are being tackled with. I'm following the order in the paper that's been sent out. Hopefully you will have had that, and if not, send an email or a comment in chat and we'll get one sent to you. So the first bit, which I suppose in some ways actually comes at the end of the claim, is the question of damages. Well, I say that it's quite important to have a rough sense of the value of a claim early on, particularly if it's a counterclaim, because you need to obviously understand what the impact of any set-off will be on the claim for possession. So, as I say, this paper is drafted by my colleague Martin, who's been doing this work for a very long time. And you'll see there's quite a lot of historical perspective in this paper. So it talks about the approach that used to be taken really before I did much of this kind of law at all, before the case of Shine and English Churches Housing Group. At that time, there'd be a global award. And at that time also, because of that, it was probably more important to have comparatives from other cases, because there'd be a common expectation that a particular kind of level of disrepair would correlate to a particular level of damages. But now, invariably, the courts approach this as a claim for diminution of rent. So the starting point for any kind of idea at all of what the levels of damages are likely to be is a knowledge about what the level of rent, what the rent is, because it's only then that you can start to think about how far the rent should be reduced because of the disrepair. And obviously that makes sense from a logical point of view. You've got a claim in contract, and the position of any kind of contractual damages is to put you back into the position you would have been in had the breach not taken place, and you're paying rent as your consideration for the landlord carrying out their duties. So, from a contractual law point of view, it's got an impeccable logic. The oddity, of course, is that some tenants in social housing pay very low rents, so they will generally get far less in terms of damages, and tenants paying in private rented accommodation for similar kinds of disrepair, if they're paying 2 or 3 times the rent, they'll look to recover 2 or 3 times the damages. And in the paper, Martin points out that there's a third category of cases, which is where you've got a long leasehold. So you might have a peppercorn rent of £250 a year, but nevertheless, the freeholder will have obligations towards you. In that kind of case, there's no sort of diminution of the actual rent. There's a diminution whatever the notional open market rental value would be. So that's the basic approach that's taken. But then, how do you know? So you meet your client, they complain about, a list of problems with the property. Is that, worth 10% of the rent, 25%, 75% of the rent? How can you assess that? And sometimes there's an idea that there's some kind of science to this, that barristers can look at it and work it out, but really it depends. There's no science at all, really. I mean, Martin suggests one approach which is common, which is you can look at what portion of the property is actually affected. So, if you're affected by, a bit of damp in a corner of one room, and that the property's got 3 rooms, then you can start from the presumption that, the level of damage is going to only really be very small. Whereas if a problem pervades the whole house, it's much more significant. But even there, I mean, if a room is completely unusable, let's say you've got 3 rooms and one room is completely unusable because the damp's so bad that no one can go in there, you just close the door. If damp is a problem, that's quite easy. You can say, well, there's 3 rooms, and the amount of floor space, if they're roughly equal, it's a third of the value of the property is lost. But it's very rare for problems to be as for disrepair to be as confined in that way, in a clear-cut way. So really, you're back to just pulling numbers out of a hat, and you can look at other cases for assistance, and they're reported in lag. They're of limited use, and often there's not even, well, sometimes there's not even, especially with older cases, reference to the actual rental. So you don't know what percentage of the rent is being considered, and in those cases, it's very hard to use those cases at all. So a lot turns in damages, in general damages, on the quality of evidence of the effect of the disrepair. And that's something which is often, in my experience, insufficiently particularized. If I'm drafting claims or counterclaims, often there's not enough detail of, well, 3 things. I was going to say, I'll go on to address them, but the causation of whatever the disrepair, the causation of any problems causation of problems arising from disrepair. The causation, notice is often not adequately particularized, so we don't get enough information about what it is at the beginning of the case, and the effect on the client. And the effect on the client is very significant. How has their family life been affected, if it's a family, or how, if it's an individual, how has that person's life been affected? How has their health been affected? What are their feelings about the disrepair? Do they have to make any adaptations to how they normally live in order to have workarounds? Jumping out of the shower to repressurize the boiler or whatever it may be. All of this fine detail really makes a difference when you're trying to get damages for disrepair, and it's very important to put in. I'm just going to have a quick look if there's any questions in chat. No. Can I just say, Michael, if you keep an eye on what's in chat, and if there's anything that seems, directly pertinent to something I'm saying, if you can just give me an alert, so because then it'll save me from having to listen.
Already doing it, Phil.
Okay, great. I think I better move on. I'm not going to talk about negligence, other than to say it doesn't apply. Effectively, it doesn't make any difference that it doesn't apply, because there are parallel obligations that achieve the same effect in, well, Section 4 of the Defective Premises Act, Section 11 of the Landlord Tenant Act, and now in the new, if we're talking about a hazard, then in the new fitness for human habitation provisions. So there's a comment in the or reference in the paper to mitigation of loss. So sometimes you may have a case where, I mean, you know, thinking about this, it may be mitigation of loss. The particular example given here is access, where a landlord doesn't let, where a tenant won't let people in to carry out the works. Or, I mean, I've had cases, for example, where tenants you know, slow down the works. They may insist on certain things being done in certain ways. They may say that they don't want them happening just now. They want certain, you know, particular bespoke variations to the works put in place. So the principles there are that it's a defendant that has to show that there's a failure to mitigate loss, and the courts are pretty generous to the claimants in that case, because then if the problem has been caused by the landlord, and unless the tenant's being really unreasonable, they're not going to jump up and down and blame the problem on the tenant. But in relation to the concrete problem of access, which is given here, and you know, where it's a question of access before the claim has actually crystallized, arguably there's no claim at all. It's not just simply a failure to mitigate. It's you know, the landlord hasn't yet breached their duty. They've done everything they can to try and, you know, carry out repairs, and they're prevented from doing so. But in relation to access, it is very important to drill into clients that they must let the landlord in to do works. Sometimes, in my experience, especially once they've got a solicitor involved, they say, "Oh no, you can't come in. You have to talk to my lawyer. I'm not letting you in until the lawyer says so." And that's okay if the lawyer then says yes, let them in, and they go straight in. But any kind of resistance by the tenant to the landlord getting on with the works will often be cited then back as a problem in any subsequent litigation. Special damages. Often here, the problem is, well, there can be a problem of exaggeration, and there can be a problem of evidence. So one way to think of it is that, you know, what's really useful is, you know, as far as possible, to have a table. You have the item, you prove the item, the proof that you ever possessed it in the first place, the proof that it was damaged or lost, and then proof of the value. So the value is the second-hand value of something where there's a second-hand market. And since the internet, unfortunately, perhaps some of our clients, there are a lot of second-hand markets, second-hand markets for all kinds of things. And you know, it's quite easy to find the second-hand value of things. I had a client whose entire record collection was, he said, destroyed by contaminated waste, and he actually went through every single record and found the second-hand retail value of that record and put it in a schedule of evidence, which, you know, obviously is very compelling. So proof of those four things, that you possessed it, or those three things, that you possessed it, that it was damaged, and what it's worth, are important for any special damages claim. Then in relation to disrepair claim, I can see.
Just pause to interrupt you there, Phil. There was just a quick query about you were talking about access before, and how that correlates with a situation where essentially you're getting your expert in and losing evidence.
I can see that. Yeah, well, that's a good question. I mean, I guess at that point you just have a decision to make. That is reasonable. You will be in breach of your tenancy agreement if you stop the landlord doing work, and I guess it depends partly on what the problem is, whether effectively whether the damage may be. I mean, it may be. It depends. Yeah, I don't know. It's hard to think off the top of my head of a practical situation. You do want an expert report. I mean, if work's carried out, maybe photographing things could preserve evidence. I don't know. I mean, I think you just have to think. I mean, a lot depends on how long it'll be till the expert gets in, how long you're going to have to keep the landlord out. You don't want a situation where the landlord is going to court to get injunctions against you, because that's really not going to help your case in the eye of the courts.
I think I agree with you, Phil, that it's sorry to interrupt, but I feel it is very subjective to the case about what the nature of the disrepair is. Is it something that you can just take some photos of and get an expert to comment on? You may, if you have good contacts with a particular expert, you may be able to send them some photos and say, look, do you need to get in now to be able to assist us, or can you comment on the photos and then come and look at the property even after works have been done? And it may well be that you have to get your expert moving earlier, possibly even without permission of the court, if it's a scenario where you want the expert in but you also don't want to stop their works too quickly, and that may be in discussion with appropriate discussions with the other side at that juncture as well. You may be saying to them, look, there's a conflict here, we need the evidence, but equally we don't want to be in breach of our conditions, so as long as you're not going to take issue, we'll get our expert in quickly and you can then get on with your works quickly and such like. So
and I mean, there may also be scope for for example, I had a case where the question was what was inside the roof, and it sort of makes sense to have your expert attending at the time that they're actually taking off the roof and looking at it, because then you can they can both look at it at the same time and see what's actually causing the problem. There
is another question as well that goes back to what we were dealing with at the start about calculation of damages. The question is, if a property is unfit for human habitation, could you potentially get damages for 100% of the rent?
I said that to you the other day.
Yeah, you actually asked me that question on the phone.
Yeah, that's what I thought. That was my instinct. That was my instinct. And then Michael said, "Oh, we can't find anyone else that thinks that." Right? He thought that that was my instinct. My instinct was,
if a property is unfit,
consideration. This is not a place that a human being should be. How can you get anything less than 100%? But there's no case law on it. The thing is that's the kind of argument which I think could probably be screwed up really badly if the wrong case, if the point was made on the wrong case. But it might well still be arguable. I mean, I think
my view was it's a contractual term, and it's about remedying you for that breach of that contractual term, and the fact that the property is part of, for example, as one of the participants says, if part of the property is unfit for human habitation but the rest of it isn't, then you're not going to get your 100%. If it's throughout the property, then there could well be an arguable point. It's certainly something that I haven't seen tested yet, but that should be tested, and it isn't a crazy suggestion. The only, and certainly if you're in a contested case, it's worth running the argument where you think it has merit. And I think it's more likely that 100% cases may arise than previously did with disrepair, but I'm not necessarily sure it kind of applies across the board, is what I'm thinking. But we're in a situation where this hasn't been really tested yet. I appreciate the provision's been around since 2019 now, but we haven't had much housing law in the court since then. So,
no.
So certainly worth. I think it's worth a punt. The only difficulty is in the certain context where you're thinking about settling a case. I think you're going to end up reverting back to old measures until you've got something that assists you in settling it on higher terms, if you can do. So there we go. That would be my view. Sorry for that. You.
Yeah, I mean, just on that concrete question, Rachel. I mean, I think I don't know. I mean, I've not seen a report by an expert where they say this room is not fit for human habitation, but the legislation as a whole isn't organized like that. You know, the implied term is in relation to the premises as a whole. But we'll go on to that. So just in relation then to causation. So, and again, this is something that may become less significant the more it's possible to rely on the Section 9A, the new, well, it's not that new now, but the fitness for human habitation provision. But this is another thing that I think is just a suggestion in relation to, you know, when you first meet the client and you're looking at what information to gather, you know, at that initial point for the purpose of, you know, pleadings being drafted or, you know, a claim being put in or the counterclaim. And I think it is really important to think not just about, you know, what is wrong with the property, but to think about causation in relation to, so you're not just describing what's wrong, what's unpleasant about the property, but how is that a breach of a repairing obligation, you know, when we're thinking about disrepair. And there's two examples in the notes. One is in relation to infestation, which is at the end of the paper, and the other is in relation to damp. So in relation to infestation, and again, this may become less, or this is now less important because infestation, it can be a hazard under the that's basically makes property unfit for human habitation. But in relation to damp, it's really helpful to try and understand a little bit. You don't have to be a surveyor or a building expert, but you can ask a few questions that can open up possible causes of the damp. So, you know, just, you know, what kind of a building is it, and how does the property, where is the property damp, and what might be causing it? You know, so you know, is it worse after it rains? When you look outside on the wall where it's, you know, where there's, you know, mold growing on the inside, is it in fact the case that, you know, there's lots of moss all up the side of the wall and a gutter that's spewing over down the side of the wall? Is there, you know, is there damp that exists at a low level but not at a higher level? And, you know, and there's a sort of a salt mark sort of halfway up the wall where there might be rising damp. So, I mean, if you can have any kind of, you know, basic questions that give you a feel for what's causing the damp. If we're talking about condensation damp, you know, ask about trickle vents, ask about fans, you know, whether there's extractor fans, whether they're working, whether they look like they're working, these kinds of things, because it's much more helpful at the time you're putting in pleadings, you know, before the surveyor's got there, if you can at least identify things that suggest this is, you know, that any damp is caused by disrepair rather than just, you know, it's just the property is damp. So I'm sort of conscious that I'm slightly running out of time. So I want to move on to dealing with the provisions in relation to fitness for human habitation. So, so as Michael said, there's not much case law on this yet. So we don't know yet how the courts are going to deal with this stuff. But I'm going to try and share my screen now. Okay. So, right. So this is the term for these are provisions for fitness of human habitation, and you need to have a look at section 10, because the fitness of human habitation, this disqualifies section 9A. It should be regarded as unfit for human habitation if and only if it is so far defective and one or more of these matters is not reasonably suitable for occupation in that condition. And so the matters are repair, stability, freedom from damp. Well, you can read them. And then in relation to a dwelling in England, any prescribed hazard. Some of these are obvious. So, damps are obvious. Stability would be interesting. I wonder what an unstable property might be. But anyway, so the next thing you need to then look at is the prescribed hazards, and the list of prescribed hazards. I believe that Michael sent them out. They're all to be found in Schedule 1 of the Housing Health and Safety Rating System regulations. And again, you look down that list, there's lots of, fairly unsurprising things there. But these are the things which you need to show. These are the issues which need to arise. And then hazard is just something that may means there's a risk of harm to someone using the property. Sorry, a risk of harm as a result, which arises from a deficiency. Now, the exceptions or the exclusions are probably where the case law will become interesting. And these are some of the exclusions. So look here. The implied covenant won't be taken as requiring lessors to carry out any works or repairs for which the tenant is liable by virtue of their duty to use the premises in a tenant-like manner. I mean, that, and then there's other exceptions for where they can't get permission from landlords, from superior landlords, like freeholders, for example, or a council or some other body, or where they would have to break the law to do it, or if the whole place has been completely devastated by effectively some kind of natural disaster. But there's, in relation to this question of a duty to use the premises in a tenant-like manner, I think at that point, it's maybe useful to think about the concrete question of condensation as a way of thinking about this. Now, interestingly, there was a very useful report by the Housing Ombudsman last year, Spotlight on Damp and Mold. It's not lifestyle. And I think this may be very helpful to tenants, where there's condensation there and the landlord says, oh, it's the tenant's fault. You're not, it's the way you're living. You're not opening the windows. You're not heating the place properly. You put all your clothes on the radiators, and that's what's causing the damp and mold. And there are lots of helpful points which the Housing Ombudsman makes in their report, and particular landlords that they highlight in particular complaints. But this comment, for example, I think is quite useful. The Ombudsman says, I hope the word lifestyle, when it may be a consequence of limited choices, is banished from the vernacular. And arguably, the duty to use the premises in a tenant-like manner. I think there must be possible arguments there. What the Ombudsman points out is that where someone has no choice in the matter. So, for example, I mean, the two obvious things that come to mind are fuel poverty and overcrowding. And there may well be arguments that, if a tenant, they have children, they're doing everything they can to move into bigger accommodation, but none's offered to them, none's available to them, they can't afford any. Is that a breach of a duty to act in a tenant-like manner? I mean, it would seem a bit unfair, because to breach a duty, you might expect that you'd have that would be a choice. If there's no choice, can there really be a breach of a duty? That would be, I suppose, an argument that would be interesting to see how it develops and how the courts approach it. Having said that, it will be, or it is, it is critical in, well, whether Section 9A cases or other disrepair cases, it is crucial to really get across to tenants early on, what condensation damp means, and to stress to them that, it would be really helpful if they don't dry their clothes on the radiators as far as possible. They make sure that any trickle vents are open, or use any other ventilation. Make sure they turn on the extractor fan, and adopt all of the, do everything that the landlord will highlight. Because if they're doing that and there's still condensation damp, then on the face of it, there's a much stronger case that the thing that needs to change is how the landlord approaches it, not how the tenant needs to approach it. I mean, obviously, if it's something they haven't got any control over, like, they can't realistically chuck half of the household out on the street, or they can't, heat the property if they literally can't afford it. But things that are within their power to do, as far as possible, they should indeed be doing. What next? I can't see anyone now.
Can you hear me? Yeah. Rachel has posed a question, which is
okay
in relation to a fitness for habitation. I think you're going to be coming up to a point anyway, but she says it seems to be a difficulty with fitness that the property is either fit or unfit, and not on a scale of severity in the way that disrepair matters are. If, for example, there's no disrepair, but there is some level of mold, and there could be improvements, for example, installing vents, fans, etc., but it's not so bad it is entirely unfit, then it seems the fitness provisions don't really get you anywhere.
Yeah, well, I mean, I'd have thought the thing there is, this is where it's going to turn on expert evidence, and it's going to be expert evidence from someone who, is experienced in environmental health, probably, because you're going to need a report from an expert, someone with some kind of environmental health expertise, who can basically make that decision. Because yes, there has to be some kind of hazard, but obviously there's spectrum. You could have a little bit of damp or a lot of damp, and there's a cutoff, and someone has to say, well, yes, but this actually is not just a minor problem. At this level, these premises are not fit for habitation, and that is something which I don't know how far it's going to be possible for the courts. I mean, ultimately the question will be one for the courts, but I'd have thought that an expert report would be pretty decisive there. And if it's a singly joint instructed expert, then there's not going to be much room for arguing about it. But I mean, there may well be room for arguing about it, and I guess it could get very technical if there are different experts instructed by each side. Another thing that's interesting here in this law is that, and this is something, again, I was talking to Michael just before, there's no provision, if if we go back to section 9, there's nothing there that refers to any kind of. So these are the circumstances in which they don't have to carry out works. You know, if they can't get permission from a superior landlord, for example. But there's nothing there which says, you know, that there's any kind of sort of excessive costs that they shouldn't have to bear, or that, you know, any kind of reasonableness test. I mean, I guess courts are always happy to impose a reasonableness test, but there's no limit. I mean, this is interesting. You know, I had a case recently, and the expert had identified a few things that he said. So basically, installing a ventilator somewhere, installing a radiator somewhere else. And he said these were things that should be done to make the property fit for human habitation. But he then raised the issue of cavity wall insulation and said, well, maybe if there isn't any cavity wall insulation, that would help. But he didn't sort of prescribe that as in a schedule of works. But and the judge indicated, and I dealt with it by sticking it in the list of things we wanted the court to order anyway. But the judge sort of indicated, oh, well, I'm not going to do that because that would be expensive. But, you know, on the face of it, there's nothing really, if that would be something which would make the property fit for human habitation, where it's currently not, as far as I can see, there's nothing that imposes any kind of financial restriction on what can be done. So that's that. So anyway, I'm going to move on now. There's a brief point here about estimating the value of the claim. So, you know, when you file and serve a claim or a counterclaim, you have to obviously estimate the value of the claim and then pay a fee based on that. There's two things to say. One is, don't worry if you underestimate, because you can apply to amend it later. But on the other hand, be aware, particularly if you're trying to, in a possession claim and you're trying to fend off a ground 8 claim, if you underestimate to the extent that you know, there's a risk that that even if you get everything you're asking for, you'll still be below ground 8. You know, obviously, you know, don't say a figure that isn't realistic. But don't, on the other hand, think, well, I just put in a low matter now, pay a small fee, and we can always top it up later. Because, you know, I certainly had a case recently where we'd put in a figure and the judge said, well, it'd be an abuse. The strongest you're asking for, you can't now argue in response to the landlord trying to get summary possession at an interim hearing. The judge said, you can't now argue that actually you're going to get more than that. You know, I'm going to take your claim at the strongest. At the strongest, you're still not going to beat ground 8. So be wary of that. Counterclaims at the warrant stage. So this is fairly straightforward. You can bring a counterclaim right up to effectively the moment of execution. There's no problem with that. And if it's a discretionary tenancy where the warrant can be, you know, where the court's got the power to repeatedly suspend any warrant for possession, then you can argue that it's highly relevant to a decision to suspend a warrant if there's a high value counterclaim that may reduce rent arrears. When the court considers whether or not to add any counterclaim to the claim or whether to ask it to be run separately, CPR 20.9 applies. But in my experience, usually it's relatively straightforward to persuade a court that, you know, the two claims are bound up with each other in such a way that it should be added. I'm not going to say much about retaliatory eviction because I've only got 2 minutes left, and it really, I've still not yet found a case where it applies. So it's all set out in section 33 and 34 of the Deregulation Act. Then you see a complaint to the landlord, then a complaint to environmental health. And at some point along this path, there needs to be a section 21 notice. And then also there needs to be a service of either an improvement notice or a remedial notice. So those are the two documents that need to be served. And if you need to know the exact framework, just look at the law. But limitation, there's just a couple of things I want to say, really. The first thing is that it's worth bearing in mind, because it's not always appreciated, that, well, there's two things particularly worth bearing in mind. One is that limitation is a defense, so it has to be raised by the other side. It's not something that we need to worry about. And if they don't raise it, tough. You know, if they forget to file a defense or they don't notice it, tough. The second thing is that if you're bringing a counterclaim and effectively you're asking for the disrepair to be offset against the rent arrears, then to the extent that it's an offset, it's effectively a request for equitable relief. And equitable remedies are dealt with in section 36 of the Limitation Act, and basically there's no time limit. So, you know, if you've got a counterclaim, there's no time limit at all. There's no limitation. You can rely on, you know, disrepair that goes back to the 1970s if you want to. In principle, there's no time limit. Obviously, if you start to exceed the level of arrears, then it's no longer an equitable remedy. It's then actually a claim. So, you know, it doesn't work that way. Notice. I mean, there's a difference between the kind of notice that's required under the Section 11 and Section 9A of the Landlord and Tenants Act and the Defective Premises Act. I think the paper hasn't really clarified that, unfortunately. And there's also a difference. There's the Defective Premises Act has a provision that the landlord ought to know, in particular where the landlord's got a duty to carry out repairs that effectively they can be a kind of constructive notice. The thing about notice that I wanted to highlight really though is that from the point of view of when you meet the client, it's really, really useful to actually get as much detail as you can at an early stage about the notice. So who did you speak to, or who did you see? When did you go there? You know, if you don't know exactly when, estimate. What did you say? What were you talking about? It's not just a question of notice for all the disrepair. Which issue did you raise with whom at what time? Knowing that and being able to specify that at an early stage makes a claim look much more credible when the courts are considering it. Okay, I better go. That's my time up. So, Michael, over to you.
Hello. Okay, so my thing today is talking about Environmental Protection Act prosecutions in the Magistrates' Court. I've been banging on about these for a few years now. I think we don't do enough of them. I would encourage solicitors to do more of it. I think it has a number of substantial benefits for both the client and the solicitor. The primary points being that invariably it results in works getting done and getting done promptly. It can be quite the trigger to that. It invariably results in compensation, albeit maybe not the full amount a client's entitled to, but some compensation for the client, and it gets a decent cost awards for the lawyers that are involved. Now, a lot of people have suggested to me, invariably it tends to be the lawyers for the other side on these cases, for the landlords, that these cases are just about ramping up costs for the tenants' lawyers. But one, that's invariably caused by the way the landlords behave in cases where they are alleging that. And while it can be lucrative for lawyers, it also gets works done and gets compensation for your client promptly. And equally, it's no bad thing for those of us who do a lot of legal aid work to be paid well for once, because it's the only way we can really subsidize the poor pay that we're getting in other fields. Particularly with things coming up on the horizon in relation to the potential costs issues coming up in relation to fast track and multi-track cases, and the concerns that we have on that field. EPA should be given a fresh look. I think that they're not done enough. I think that the fitness for habitation provisions of the implied terms that have come in haven't been haven't seen the great results that we were all hoping and expecting. And indeed, as Rachel highlighted earlier, we're having problems getting over the threshold of establishing that the property is not suitable to occupy as a consequence. Whereas I feel that establishing a statutory nuisance and pursuing a case under the EPA is something that's still possible and still feasible and can still get good results. Now, it's important to highlight as well, for those of you who are here who may not have gone near the EPA for a while or not done any EPA prosecutions ever before, one of the most important authorities on EPAs is Pears House and Birmingham City Council. It should be included in any skeleton argument that you ever seek to rely on in a case when you're representing a tenant, because it emphasizes that these proceedings should be a simple procedure for private citizens. I've put the quote at paragraph 56 of the notes, which I hope you've all got the link for and been able to download by now. This is Bingham, I think in the Court of Appeal at that point, saying it would frustrate the clear intention of Parliament if the procedure provided for by Section 82 were to become bogged down in unnecessary technicality or undue literalism. It is important that the system should be operable by people who may be neither very sophisticated nor very articulate, and who may not, in some cases, unlike this appellant, have the benefit of specialized and high quality advice. Now, as somebody who is neither very sophisticated nor very articulate, I'm always very grateful for that quote, because essentially it makes the point that these technical points that invariably professional landlords try to run shouldn't be going anywhere. And despite this case being the leading authority on the point, commercially minded landlords, such as local, invariably housing associations more so than local authorities, will try to raise technical and literal arguments all the way through. And the point is, stick to your guns. All they're actually doing is racking up their cost bill at the end of the day. 9 times out of 10, their arguments have no legs at all, and authorities of a similar nature to Pears House will back you up on that in relation to EPA prosecutions. So it's a simple procedure. It should be a simple procedure. It can get good results, and you can get good consequences. I've summarized again at paragraph 57 the pros, and I've spent a bit of time on that already, so I'm not going to spend much more time on that. The only other thing that I would highlight is, essentially, provided you're conducting yourself properly and you're conducting the litigation consistent in a proper manner and not in a wasted costs-esque manner, so in such a poor manner that somebody make a wasted cost order against you, you and your client are to a large extent cost protected. There's no power for the court to order a prosecutor to pay costs to a defendant. If a defendant is successful, they're entitled to costs from central funds. So so that's the only other benefit as well, which is worth noting. In relation to disadvantages, there are some. I don't want to skim over them too much, but essentially they only arise where there's a statutory nuisance. So other elements of housing conditions can't be covered by an EPA prosecution. You do have to prove your case beyond reasonable doubt. It's a higher threshold. It can be hard in circumstances, but I think provided you've got some solid expert evidence that establishes the point, you're very unlikely to not meet that threshold, particularly where the experts agree in any event. And there can be criminal, the procedural rules are more stringent, and you need to just keep an eye on that as you're going through the case. And that can end up causing you to slip up technically, because criminal procedure does have some technical elements, but provided that you've got somebody on board who knows about criminal law, you should be okay. So if you want to, second opinion from counsel who's got a criminal background as well as a housing background, that's the way that you deal with that. And it's not that complicated, particularly in an EPA prosecution. And I would return back to the point that I say about Pear's House. These cases shouldn't fall down on technicalities and pettifoggery. There are strict disclosure obligations on the tenant, and no disclosure on obligations on the landlord, and that can trump privilege. So if you've got privileged material that undermines your case, then you may well have to disclose that or consider withdrawing the case. And finally, the cost awards can be limited. They're no longer financially limited. There's no longer a cap on it, but the time for which the compensation can apply to is limited by the fact that essentially it's a summary offence. I'll come to that later as well. And equally, one of the disadvantages for most of the solicitors who I imagine are here is that there's no legal aid funding for that. But as I say, the opportunity to recover the cost from the other side commercial rates can be quite lucrative in that sense. When can you pursue a prosecution? Essentially, you have to have a tenant that is aggrieved by a statutory nuisance, and you have to have a defendant who's the owner of the premises or responsible for the nuisance. I'll go into that in a little bit more detail shortly. And before the tenant issued the proceedings, they gave the landlord notice specifying that the matter of specifying the matter complained of not less than 21 days in writing of their intention to start proceedings. I'll come to the notice requirements shortly as well, but it's essentially statutory nuisance can cover a large volume of things. In paragraph 59 of my notes, I do list those, but essentially I'm trying to check, but I think practically all of the cases I've ever done, I think indeed all of the cases I've ever done for a tenant, you are looking at 79A, which is any premises are in such a state as to be prejudicial to health or a nuisance. And it's the prejudicial to health limb that you're going to be heading down. That's there are all these other areas that you can look at, but in reality, it's going to be establishing prejudicial to health. You're 9 times out of 10, these are damp cases, and it's mold that you're talking about. The issue of whether or not something is prejudicial to health is outside of the expertise of the tribunal. They have to have expert evidence. And it needs to be somebody who's suitably qualified. So it needs to be an environmental health officer or a surveyor with relevant qualifications. There is authority to the effect that a chartered surveyor is not good enough. Now, so you're looking for somebody who's got environmental health expertise, and they do need to provide a report to that effect. In 9 times out of 10 in the cases I've done it, the tenant has got it right and they briefed an environmental health officer, and then the landlord has breached a chartered surveyor, which is ever so helpful because their evidence is going to be given less weight and in fact has less authority as a matter of law than an environmental health officer. So, but keep an eye, make sure you're instructing the right person at the start. The focus when you're looking at the statutory nuisance is the effect it's having rather than the cause of the nuisance itself. Clearly, it's still necessary to establish that the statutory nuisance is caused by something of which the defendant is the owner or is responsible for, but this is a much more limited requirement than the where you are when you're in the civil courts and you're establishing a breach of contract. Indeed, a landlord can be responsible for a statutory nuisance without having breached any terms of the contract. So you don't need to get over Section 11 or the interpretation provisions or anything like that. You just have to show that there is a statutory nuisance in the premises, and the landlord is either or the individual that you're prosecuting is either the owner of the premises, which I'll come to shortly, or responsible in the sense that a default on their part has done that, and a default can be their failure to put in place an improvement. For example, moving the radiators to being under the windows, putting in extractor fans in the right places, and such like. So putting in insulation, properly insulated walls and such like, or dry lining and things like that. So that's the focus is more so on that than looking for a breach, so to speak, of their responsibilities. You've got to focus on establishing the statutory nuisance. Where somebody is an owner of premises, essentially the individuals responsible under Section 82.4 can be quite broad, and there can be multiple people who are responsible, including your client. Let's not forget the standard refrain where we're complaining about mold and damp in a property is from the landlord as well. The tenant's been drying their towels on the radiators, they've been drying clothes inside, they've not been properly ventilating the property, they've disconnected the extractor fan, all of that. Now that is that can be relevant, and if they can establish that your client is wholly responsible, then they do have a defense. But they have to do that. They have to show that they're wholly responsible, and not, as is normally the case, that they may well be contributing to it with some of their conduct, but that equally, if the premises were adjusted in a certain way, that would remedy the defects, that would address the problems with mold arising as well, because there can be multiple people responsible, and all of whom can be prosecuted, and the fact that somebody else is equally responsible does not mean that you have a defence to a prosecution under the EPA. The owner, for the purposes of Part 3 of the Environmental Protection Act, is the person for the time being receiving the rack rent of the premises in connection with the word is used, whether on his own account or as an agent or a trustee of any other person, or who would so receive the rack rent if the premises were let at a rack rent. So essentially, it's the person getting the market rent is normally regarded as the owner. So that would normally be your direct landlord. If there's a leaseholder and then a freeholder, then the initial person would be the leaseholder. It may well be, however, that the freeholder has some kind of responsibility as well. So it may well be, for example, in a block of flats, that you've got a local authority who owns the property, a housing association that has the leasehold in the flat, and your client is renting from them, or a private landlord, for example. It may well be that you are prosecuting both the leaseholder and the freeholder, because the overall structure of the building, the poor insulation on the outside of the building, is one of the factors for which the freeholder is responsible, and you equally may well have a claim against, and equally the leaseholder is responsible as the owner of the premises because they're receiving the rack rent, the market rent from you, and equally and they equally have the ability to make adjustments in the property, for example, dry lining, putting in insulation, putting in ventilation, and adjusting the heating provision. So it may well be that you decide to go after numerous people. Invariably, it's helpful to do that, at least initially, because they then start flinging mud at each other rather than back at you, and you will end up eventually getting the right person, provided you've got sufficient evidence that would justify an action against either of them. It's probably advisable to go after both. So they're the people. That's the people responsible, or the owners, that you need to think about. And as I highlight again at paragraph 67, where the tenant's contributing to the nuisance by their own conduct, this does not amount to a defence for the landlord. So that is more helpful than what you sometimes experience in the county courts. Notice, when it comes to these proceedings, you do have to give notice to the other side 21 days before. Now, this can be quite a helpful tool in its own right, because it may well be that your client just wants them to do something about this, and just wants them to get the works done. He could care less about damages, he could care less about anything else. He just wants them to get the work done, and the threat of an EPA prosecution on 21 days notice, with a sensible landlord, should trigger them to get the statutory nuisance removed and get the works done that will abate it from recurring in the future as promptly as possible. So even if you're not necessarily inclined to go the whole way, I would advise, if you have a standard letter before action, adding one simple paragraph to that letter before action that says, just so you know, we're also treating this as a notice pursuant to section 82 of the Environmental Protection Act, and upon this is your 21 days notice, and if no action is taken to remedy the defects, we will also reserve the right to pursue a prosecution in the magistrate's court. The notice invariably can be quite the litigation point for housing association landlords. To date, over the years of me doing these cases, I've never seen them successfully establish that a notice is not valid. And that's again down to the authorities on this. The authorities are fairless, and again, you refer to Pear's House as well. Essentially, provided you've told the landlord ballpark what's going on at the property, and said, and if you don't do some, and said this is your 21 days notice before we go to magistrate's court, that's good enough. And it doesn't need to be a technical document. These, as they always remind us in the authorities, these are letters that should be able to be written by lay individuals, not litigants. They don't need to have any expertise. So they don't need to say, oh, it's damp being caused by X, Y, and Z. You don't need an expert's report to serve a notice. It just needs to say, there's a problem at the property. For our client, for the tenant, they are suffering X, Y, and Z. We have seen some, and that's about it. You can go into a little bit more detail. It doesn't harm to possibly put in some photographs of what you're looking at. It doesn't hurt to say, we suspect the damp is being caused by a big hole in the roof that we've seen, but equally, you're not bound by that, and you aren't required to go into such detail. It's essentially, there's a problem at the property in this ballpark area. We want you to fix it. Here's your 21 days notice. And don't be worried if the other side raise an issue about the notice. They 9 times out of 10 they do, but I have not seen, as I say, them successfully strike these things out, at least not to then be then overturned by the High Court. But certainly in my cases, I've never had to even go that far. They will. It's raised as a technical point, but again, as I say, the technicalities and pettifoggery shouldn't be of concern. And again, I quote a series of authorities in paragraphs from paragraph 68 through to 70, which deal with that point. So if it does come up, you've got all those authorities there to rely on. It is advisable to include the stuff I've provided at paragraph 71 of my notes. So the name of the tenant, the details, the address of the premises, some kind of ballpark idea of what the problem is, and an unequivocal statement of an intent to pursue prosecution that expire over the period of notice, which is not less than 21 days. The notice must be served on the person responsible or the owner as appropriate, but again, don't get too concerned about precisely who, particularly with the big corporations and with local authorities. That can get technically quite complicated. There is provision in section 160 for it to be served on the secretary or clerk of a body. But the more recent authority of London Borough of Ealing and Allen reiterated the point that we shouldn't be getting stuck down in technicalities about it being served on the wrong individual at a body. Provided that, and has highlighted that the section 160 of the EPA is permissive rather than mandatory. So provided that a notice is validly served, is delivered or posted to the registered or principal place of business of the body corporate, when addressed to that body without further identification, then that will be a sufficient notice for the purposes of section 82. But again, don't get too concerned about it. Just worst case scenario, if you think there are multiple different people who should be served with this at a relevant body, just send copies of the letter to all of them. You then, once you've had your 21 days up, and if nothing's actually happened, sorry, I just saw a question from Walata there on the section 21 notice, and on the second question, because it seemed right on the point about what I was saying. My view is it's not an abuse process, it's a separate proceedings. You're entitled to serve a Section 82 notice at any point, whether or not, Wallata asks whether or not you can serve an 82 notice, whether or not you've got civil proceedings ongoing, even if they've started progressing. My view is no, you can serve a Section 82 notice at any point. The fact that the civil proceedings wouldn't make it an abusive process to do it in the criminal courts. Invariably, I know solicitors who have it as a standard paragraph on any letter before action, which relates to civil proceedings, but they also say, oh, by the way, then we're going to pursue criminal proceedings. I don't see it being an abuse unless you've settled those civil proceedings and it deals with all the works that are concerned. I think there could then be issues, but I think with ongoing civil proceedings, I don't see a problem with you serving a Section 21 notice and contemplating a EPA prosecution. Just looking at the earlier question you put. Yeah, we had again, Wallata, you talk about a scenario where you had a surveyor who provided evidence and the court decided the evidence should have been given from an environmental health officer. That's exactly what I was saying. There is authority to the effect that if the individual doesn't have environmental health expertise, whether they're an environmental health officer or they're a surveyor with those additional qualifications, then their evidence is not going to be treated as sufficient for the court. Anyway, moving on, in relation to laying an information, until relatively recently, you had to formally prepare an information. But now, rather helpfully, when they updated the criminal procedure rules, they provided a form that you fill out. And I reference it and provide the link in my notes at paragraph 73. And that meets all the requirements, of which there are quite a lot more now. Before you issue a prosecution, all kinds of statements that you need to make, all kinds of undertakings you need to give. And it's important that you use that form. If you don't use that form, you're likely to find that your prosecution could be challenged later down the line, and you could end up incurring a lot of costs that are then not recovered because the court isn't able to proceed on that basis. And don't assume that if a court just carries on because you've sent them some paperwork but not the right paperwork that you're still good. You need to make sure that form's put in at the start. Otherwise, you may well be withdrawing your prosecution and starting over again, which you don't want to be doing. Because, and this is very important, at the stage when you lay the information, when you make this application, you want there to be evidence of a statute nuisance of the property, because your costs on a Section 82 prosecution only arise if there was a statute nuisance at the time the information is laid, so at the time the application to the court is made. If you haven't got a statute nuisance then you will not be entitled to your costs for proceedings. If the statute nuisance is remedied after that, you would still be entitled to your costs. But you need to make sure there is a statute nuisance at the point when you go and lay your information. So this is, and you're going to need to be able to establish that to the criminal standard. So this is where you will need to have some expert evidence. This is the first visit you're going to have from your expert. You're going to send in your expert, and you're going to want to know as quickly as possible from your expert whether or not there's a statutory nuisance. And the minute that they tell you there's a statutory nuisance, you want to get that application into the magistrate's court. What you don't want is a substantial delay between your expert evidence and your application to the magistrate's court. Now, that can be problematic with some experts. They may be prone to producing a report 2 or 3 weeks after they've gone to visit the property. But actually, the way of dealing with that, even with those experts, is to call them up, to send them a letter saying, look, are you going to find in your report that this is a statutory nuisance case, that this property is prejudicial to health? If they say yes, then crack on and get your information. You don't need the expert's report at that point, but you do not want there to be a substantial delay between the expert's evidence and the notice being laid, because every bit of delay is a possibility for something to change in the nature of the property that allows them to argue, well, actually, you can't be sure on the criminal standard that there was a statutory nuisance on the day the information was laid. It may well be that it's a few days, and that is quite common between those two steps. But you're going to want to check with your client on that day when you're putting it in. Just contact your client and go, look, has anything changed since the expert gone in? Has anybody come and done any works? Has anything, you know, drastic happened to the mold? You haven't done a cleanup job, have you? Anything like that? And make sure that you have that situation, so that you can be sure that there was statutory nuisance when you lodge the information. So that's a paper process. You put that in, you lodge that with the court, and then they're going to list you. They're going to summons the defendant or defendants, depending, the landlords, and you're going to have a first hearing. Now, at the first hearing, essentially, that's your that's your standard first hearing in the magistrate's court, where either the defendants are going to plead guilty, in which case you will be dealing with sentencing, compensation, or all of that, or they're going to go not guilty. I have to say it's a lot more common for landlords to go not guilty, because for you to get for them to get a criminal record, you have to establish a statutory nuisance at the date of the hearing. And if they say not guilty at that point, they still have until the trial to try and abate the nuisance, to avoid getting that criminal conviction and avoid being subject to a fine and compensation order. So even if they aren't not guilty, they will invariably say not guilty at that point to buy themselves some more time. It's always worth canvassing with them beforehand whether or not they're going to give an indication as to what their plea is going to be in the days before, so that if they are going to be pleading guilty, maybe you can you're prepared with submissions on sentencing and your costs. You've got a cost schedule ready and such like, and your damages award as to how much you're asking for in compensation. They may well be willing to do that. Equally, they may well be willing to compromise the case, provided that the prosecution is withdrawn. So they may be willing to agree a schedule of works, a series of a payment of damages to your client and your costs before that hearing. But again, invariably that tends to happen after they've entered the not guilty plea. But again, all things worth exploring as early as possible with the defendants to see if you can nip everything in the bud and save everybody a lot of money and time. If the case does go on a not guilty plea, then you're then going to be looking at case managing the case. Now, the magistrates court do have a standard form. Sorry, 1 second. That they use when somebody enters a not guilty plea, called preparation for trial in the magistrates court. Now, most of that form is not relevant to EPA prosecutions. It asks things like, will you be relying on DNA evidence? Are you going to put in your interview as a transcript, or will you be playing it? And all these kinds of things, which just have no correlation to EPA prosecutions. And equally, it's then missing the stuff that you want the defendant to address at that first hearing. So what I have done is sent out a draft of the form I like to use for everybody to have a look at. Obviously, you may want to amend it yourself, but what you want to do at that first hearing is firstly throw your defendant's minded brain out, because a lot of us have done criminal defense work or will have been involved in criminal defense work in the past, and we as defendants hate those forms because they try to pin you down, they try to get you to make admissions, they try to get you to narrow your defense as early as possible and narrow the issues, whereas a defendant invariably wants to exercise their right not to self-incriminate and to keep everything open and essentially, at the very least, put the prosecution to proof on all matters. And so instinctively, those of us who've done that in the past may well be amenable to arguments from the defense. Oh, well, we don't really need to agree to these things now. We don't really need to narrow this down at this point. We're entitled to, defendants to criminal proceedings. We're entitled to hold back from making these points until the trial comes along. And so you don't want to kind of leave yourselves open to those arguments, and be well aware that a judge is on your side for once. If you're used to being the other side of that argument, where your defense counsel in a criminal case, judges kind of almost bully you to try and make some admissions at that first hearing, and you are prosecuting now. You're prosecuting a landlord, and you're likely to have a judge helping you out at that first hearing, saying, "Well, yes, why can't you admit whether or not you're the owner? You know whether you're the owner. kind of thing. So you want to put those questions to them in the form that I've put in there about whether or not you're admitting you're an owner, whether or not you're challenging the validity of the notice, because you want to narrow down as many of the issues as possible at this stage. And a judge will support you. And equally, even if the judge doesn't support you, and even if they just strike a line through those admissions or denials that you've put in there as questions, when it comes to costs later down the line, and they say, oh, well, this was unreasonable for them to have put in all this evidence and all these points dealing with all of this stuff, it's very simple for you then as a prosecutor to go back and say, well, we had to, because they refused to narrow the issues when they should have done on the form. They refused to make any admissions. We had to prove every element. We had to incur these costs. We had to do all this work, and it's entirely justified on that basis. So try your best to get them to narrow the issues on the form. Equally, if they are taking technical points, you want to get them to list those for preliminary hearings, because the final trial is probably one of your most expensive parts of the proceedings. Not so much for instructing counsel or solicitors, because you're both operating, well, solicitors obviously your own firm, so it is your cost, but you're working on a CFA, and your counsel should be working on a CFA. But you can't have your surveyor working on a CFA because of his duties to the court. So you will have to outlay for the surveyor to go and visit the property just before the trial. What you don't want is to do all that work, pay for that surveyor, have the trial, and then get kicked out on some small technicality about the notice or something like that. You prefer to get those issues dealt with at a preliminary hearing. Invariably, you're going to win on it anyway, as I said before, but you want to get them listed for a preliminary hearing. If there's any issue with the notice, if there's any issue around ownership, if there's any issue around technical points, invite the court to list that for a preliminary hearing first. Also, when you're doing that, invite the claimant who's raising those issues to have to put in a skeleton argument on those issues first. 9 times out of 10, what that will actually mean is that A, you don't ever see a skeleton argument, and B, you don't even get to the hearing, because what happens 9 times out of 10 is they say, we're taking these preliminary points. They then get to the point where they've got to brief counsel to draft a skeleton argument for the landlord, and they realize it costs them money, and actually it's a stupid point in the first place, so they invariably drop the point and make the admission at that point by way of a Section 10 admission. They are the owners. They do accept the validity of the notice and such like, so that you can then go into the trial a lot smoother. You've cut away you've narrowed down a lot of the issues, and you're focusing in then purely possibly on the expert evidence that you're going to get that week of the trial. That's another thing that's important to do as well at this stage, at that first hearing. You want directions for the expert evidence. You're not entitled to just get expert evidence and turn up on the day of trial with additional expert evidence. Judges in criminal courts do not like people turning up at the last minute with evidence that they haven't had permission for. But you absolutely need expert evidence. If the nuisance is still ongoing, that is, then you need expert evidence, or it's been cleared up but it's going to come back. You need an expert to attend immediately before the trial, because it's on the date of the trial that you need to establish a statutory nuisance to be able to get the abatement order. So you will want a direction for experts to attend, and you're going to want to fix the dates for all of these. So you're going to need your dates to avoid at that hearing. So you're going to want to fix your trial. You're going to get given your trial date by the magistrate's court. You're then going to say, well, at some point in that week before, we want our expert to be able to attend on this date. Their expert will attend as well. We'll narrow equally directions for the issues to be narrowed down between the experts. So hopefully by the day of trial, you'll have a joint report from the experts saying, actually, we agree there's a statutory nuisance, there's some dispute about this, this, and that, but and you may well not have to go to trial because matters can be settled. Or equally, your experts may be in agreement that there is no longer a statutory nuisance, and therefore your issue may well be focused down purely to costs by that point. But it narrows the issues, but you do need those directions. You're not going to be able to just turn up on the day with additional expert evidence close to the trial without having got permission from the court for that first. Just moving on through my notes. As I say, when you come to the trial, you're going to be wanting to establish a statutory nuisance, so you need your expert there, and you'll need your expert to have gone in just beforehand. Be aware as you're going through that there are substantially more complex rules around bad character evidence and hearsay evidence. So you may well be wanting to just exhibit documents or records or emails of things. Again, look at the rules. Are you going to be able to do that? Do you need to make a hearsay application? Do you want to refer to the fact that this housing association is particularly prone to being prosecuted and convicted for EPA prosecutions? You may well want to do that. If you're regularly doing these, you'll get to a point where you know that a particular landlord, professional landlord, has been subject to orders in the past and that is bad character evidence, and you're entitled to rely on that. And there's good reason to rely on that to show this isn't just a one-off. These people are at it all the time, and they're not coming to you with very clean hands at all. I just saw a question come in there. I'm just going to quickly look at it. Yeah, that is correct. Sorry, Julia was asking whether you want to get the expert out twice. Yes, if they haven't come and sorted out, as far as your client's concerned, if they haven't come and sorted out the statutory nuisance, then you're going to need the expert to go a second time. It may well be before the trial. You need the one to be there before you lay the information. So you need the expert then, and then or as close to the information as possible. And then if this statutory nuisance is ongoing or works haven't been done, so it's going to come back, you're going to want the expert evidence before the trial. Now, if you've got a scenario where you lay the information when there's a statutory nuisance, but then the landlord does get their act into gear and behave themselves, which is the advisable course of action for any landlord facing these prosecutions. I appreciate I've been kind of focusing this talk more at those who represent tenants, but for anybody who's here on behalf of a landlord, I would always advise get the works done, bring an end to proceedings as quickly as possible. That's the way to resolve these cases. So if a landlord is sensible and has done the works, there may still be an issue outstanding around costs by the time of the trial, but it may well be that your client says, you know what, they've put in some great extractor fans, they've redone the central heating, the place is great, I'm even drying my stuff inside and there's still never any mold anymore. It's a completely different property. I mean, obviously that's, at the highest level, but you may get something from your client saying, look, as far as I'm concerned, the problem's been solved by their works. I'm happy with the situation. You may not then be instructing the expert to go in, because you may just be saying, well, actually, fine, we accept that. We accept that necessary works have been done to satisfactory standard. And as a consequence, what we're only asking for now is the cost of these proceedings. At that point, and I'll come to this slightly later, the issue in the proceedings becomes narrowed substantially down to whether there was a statutory nuisance at the date that the information was laid. You're equally in a position where your client can't get compensation as a matter of law by order of the court, because the court can only order compensation if they find the offence is proven at the time of the trial. That doesn't mean, however, that your client can't get compensation by other means, because it may well be that you issued the action on a letter before action. You served your notice and it was part of a letter before action. You may have started civil proceedings. You may not have even got around to civil proceedings. You may never be thinking of even bothering with civil proceedings. But as far as the landlord is concerned, they don't know that. And there's every reason to try at this juncture, even if they've done all the works and dealt with it, and say, yeah, okay, that's fine. But actually, you left this property in a right state for months or years. And our client, even if we settle these proceedings, our client has got lots of evidence that we will rely on in civil proceedings. And we'd invite you, therefore, to make a proposition to settle the whole lot, including a damages award for our client, some compensation for our client. And with the pressure of ongoing criminal proceedings, you can find that you can get some good results that way without even having to bother start drafting a particulars of claim. And it may be that you're in a position that you weren't even going to do that, but they don't know that. And it can tactically get you into a position where your client gets some damages where they may not have been able to, whether because legal aid funding wasn't available for that, whether because you don't do civil work on a CFA in the county courts, because obviously there's the cost issues and the lack of cost protection and all of that. You can still get some kind of compensation for your client, even if you get to the point where the court won't be able to order it necessarily in the magistrate's court. just going through my notes again, as I highlighted before, with them being criminal, you'll remember that your your disclosure obligations are higher, and that privilege can be trumped. Equally, there's a realistic prospect that all the witnesses will be required to attend, and all the witnesses will be able to give both their evidence in chief and their cross-examination orally. I have to say, albeit that there's a prospect of that, if you've got nicely prepared bundles with nicely typed out witness statements, most judges and the other side will invariably agree to treat their witness statements as their evidence in chief, much in the same way as you do in civil proceedings. In fact, I've not known a case not to go that way, but be prepared for the fact that a judge may say, no, actually, these are criminal proceedings. You have to give your evidence in chief, and prepare your client for that as well. But normally can be done on the basis that evidence is tendered on the papers. Remember that a defendant may be denying all elements of the case. So if you get to half time, i.e. if you get to closing your case and you haven't proved, for example, that they're the owner of the property because you didn't bother to print off a land registry entry that showed they're a leaseholder or a freeholder of that land, then, or you didn't exhibit the tenancy agreement or things like that and get that in as evidence, you could end up falling down on a technicality. So make sure you've dotted the I's and dotted all the T's, and crossed all the T's, sorry. Because if not, you could get kicked out half time on a very small kind of minor point that you failed to address. Equally, make sure you're ready to go on the first day of trial. There are very strict rules about prosecutors being allowed to adjourn off cases. If you haven't got your witnesses and your experts there for the date, then you're going to want to be applying well before the trial date to deal with that. It's unlikely you're going to get an adjournment unless there's some very good reason why it's being made at the last minute if people don't turn up. Turning then, I'm aware that I've used up most of my time, I think, in fact, all of my time, but looking at remedies, essentially, you're going to be looking at getting a court order if the statute of use is still ongoing for them to do the works. Normally you'll be essentially asking for the court to order that they do the works as contained in the schedule to your expert's report. It may be that there are two experts report and there's a bit of toing and froing about agreeing precisely what the works are. You're going to want to make sure it's clear about by what date this needs to be done. Equally, the court is going to impose a fine on the landlord, but what you're going to want to say is actually, firstly, bear in mind you're a prosecutor and it's not your obligation to kind of ramp up the fine as much as possible. It's purely to provide guidance to the court and assistance to the court, so don't be too vociferous in trying to push up the fine. Having said that, what you may want to say is actually we care less about the fine, and indeed would have no issue with you reducing the fine provided that our client gets a decent compensation award. Focus more on the compensation, which obviously you're entitled to do. If, as I said, if there's no conviction, then you aren't able to get compensation. But if there is, and if there is an order made, then you are. You're going to want evidence about the effect that this has had on your clients already in the evidence. Remember that compensation in the criminal courts is not just for the prosecutor. It's not, in a normal criminal case, it's not the CPS who gets the compensation. It's the victims of the crime. So it may well be that your client has pursued the prosecution, but she may have a partner, she may have housemates, or she may have children. There may be a whole array of people who've been affected by this conduct. And each and every one of them is entitled to a compensation order if you can provide the evidence to demonstrate that. So don't hesitate to say, well, okay, she's entitled to a few £1,000s for the condition of her home, but equally so is her son, so is her daughter, and that's one way of getting around the limited time frame to which it does apply, because the compensation award can only be made, can only apply to the point when the offence arose, and in the context of an EPA prosecution, that's after the 21-day notice has expired, and even then, it's capped at 6 months prior to the information being laid. So if you made a 21-day notice warning and then waited a year before issuing the prosecution, you would only be able to claim back for the 6 months prior to the information being laid. I mean, the magistrates do a good job of dragging these cases out, so you can invariably end up seeking compensation for 1.5 years, 2 years, but you are time limited from when the 21-day notice expired. The amount of compensation has been unlimited since the 11th of December 2013. A lot of lawyers forget this. I still see people arguing in the magistrates' court to this day, oh, well, we're capped at £5,000 for compensation. That's just not true. And don't let anybody argue that. Highlight to them that that's been untrue since 2013. So you can get as much as you want, but as a consequence of it only being the case since 2013, there's limited authorities for big rewards out there available. Though have a look in lag, see what's going on. It's worth referencing how much the rent was if your client was paying a high amount of rent, but you do need to try and keep claims for compensation awards simple. Magistrates' courts don't like complex arguments about percentages and things like that. But if you say, look, she was paying X rent for a year and she was suffering with this, and I think she should be entitled to at least this by way of compensation, then they're going to be open to something in that regard. Equally, you may want to look at some other measure of the impact it's had on them. There isn't any broad kind of defining shine or something like that in these cases. It's a very broad brush approach. If you can find an argument that justifies the amount you're claiming, then go for it. You do want to make sure, if you are planning on pursuing civil proceedings or you have ongoing civil proceedings that are separate and that would still result in a separate award of damages, then you want to make sure that any court order that's made is very clear about for what period that compensation covers, so that you're not accused of double claiming in the county court. And then finally, just quickly, dealing with costs. Section 82 provides its own statutory regime for the recovery of costs. It requires the defendant to pay the person bringing the proceedings such amount as the court considers reasonably sufficient to compensate him for any expenses properly incurred by him in the proceedings. My view is, albeit unfortunately not so heavily backed up by recent authority in particular, is that it's arguable that that determination of costs is equivalent to the indemnity cost basis, because it's about costs having been reasonably sufficient to compensate somebody. There is no mention of proportionality, and in my view, and indeed the provisions that are provided for in the criminal procedure rules that talk about proportionality don't apply to this cost assessment, and arguably that's quite correct, because how can a costs award, in a case where essentially what you're seeking is an order for them to do works, how do you have that proportionate balance? Do you look at the value of the works? Do you look at the cost to do the work? Do you look at the loss of amenity in the property? It gets very confused, more so when you bear in mind that any compensation award is capped by virtue of the time limits, rather than the effect it's had on this person potentially for years. So and I certainly argue this point, and the courts are open to that argument as well, that it shouldn't be unduly focused on quite what damages or fines being made, and the proportionality is only by analogy. There's a rather unhelpful case out there called Notting Hill Genesis and Camberwell Green Magistrates Court. Should be emphasised from the outset that the only person at the High Court on that case was the representative for the landlord. The defendant in the case was the magistrates court. They didn't send anybody. The interested parties would normally have been the representative for the tenant. They didn't send anybody. So the representative for the landlord had a bit of a run of the High Court. It wasn't a contested case. And the observations that are made by Subson Jane in that case are unhelpful, but can be distinguished on that basis. In my view, it's not a properly contested judgment. He makes two observations which can be problematic. He talks about the fact that proportionality would be appropriate. And he also talks about the use of and billing for a grade A fee earner ought to have been considered properly and addressed by the magistrates court, given that these cases could just be run by paralegals. Now, no offence to any paralegals out there. I'm sure there are some well-qualified paralegals who could run these cases, but the point in a lot of these cases is 9 times out of 10, if you're against a housing association, is that they do instruct grade A fee earners, they do instruct exceptionally qualified counsel to oppose the cases, and it's entirely proper for you as a prosecutor to have equality of arms and to work on the case as a grade A fee earner, and to instruct suitably qualified and experienced counsel to properly prosecute the case. And that's the response to that argument. And further clarification on more recent authorities helps us with that. The case of Taylor and another on Burton is a much more reliable case where matters were contested. Justice Collins Rice in that case went on to say, this is a summary process. It's not proper parties to go into significant lengths and expense in litigating the quantum of costs, nor is it at all incumbent on the magistrates to deliver reasoned judgments on compensation or costs to be subjected to unrealistic, oppressive, needless standards of point-by-point analysis. And goes on to highlight that the point about proportionality is that they are just analogies. That Section 8212 is its own statutory mechanism for the payment of costs, and that the test is that which is contained therein. More recently, again, Fordham, Mr. Justice Fordham in the High Court provided a particularly helpful judgment. This was in a case where essentially a magistrate had approached the cost issue as though they were prosecuting a speeding fine or something, or some petty theft. Said, oh, prosecution costs £100. And the prosecutor objected and drew attention to 8212 and made lengthy submissions. And he said, well done, you tried hard, but prosecution costs £100. Their bill was £15,000. One of the defendants had settled out and agreed to pay £4,500 of those £15,000. Mr. Justice Fordham quite helpfully, robustly says that was an inappropriate approach. You have to look at the Section 8212, and the questions that are being posed by Section 212 are those three questions that I've provided for at I think it's paragraph 94 of my my notes. Here it is. The three questions, and certainly one thing that is entirely irrelevant is the financial situation of the defendant. So their means is not relevant to whether an order should be made. It's only relevant to enforcement at a later stage. The first question is, what expenses were properly incurred? So were steps taken that shouldn't have been taken? If so, they're not going to get paid for. But provided they were taken and they should have been taken, then you're entitled to the cost for that. Is the amount reasonably sufficient to compensate the private prosecutor? That's where you're most likely to see some debate. Well, why are they charging an hourly rate? Why have they used grade A fee? And it's all the stuff that we've dealt with before on cost debates. But essentially, you should be entitled to costs that have been properly incurred. And then the final question is, if there's more than one defendant responsible, how should they be allocated between them? There's no, and the important thing about reasonably sufficient to compensate is in the context of properly incurred expenses. It's focused on the sufficiency of those of the money to deal with those expenses. It's not a broader kind of reasonable costs assessment. Is it reasonably sufficient? So the focus is on the actual costs incurred and what should be paid for that. So don't be too scared. The other side will try to raise arguments on this again, particularly if they're from a housing association, but you should be entitled to your cost, and you should be entitled to a substantial award of costs. It's entirely proper for you to be billing your commercial rates on a CFA. So you should be looking at substantial cost awards in cases of this nature. It's not unheard of for the cost awards to go into tens of thousands of pounds. It's not unheard of for cost awards for merely the first appearance to go to figures in exceeding £5,000. So you are entitled to be properly paid for your work on these cases, and invariably you will recover them unless provided you've brought the right authorities to the court's attention. Another argument that I've recently seen being raised, which I deal with at paragraph 95, is some argument that you're only liable for costs in the proceedings. So the defendants try and knock out any investigatory costs, which would also include your initial briefing of your surveyor. For that very reason, it's just got to be flawed. There are authorities that make it clear that that's flawed. One deals with the Environmental Protection Act and how you're entitled to the cost of your investigation. Unfortunately, it's a different part of the Environmental Protection Act. Another authority deals with the precise wording in the proceedings on a different piece of statute, but makes it clear that the investigatory costs are recoverable on private prosecutions. I was against somebody on this issue a few months ago, and her first point when I relied on the first authority was, well, this authority deals with different wording. It doesn't deal with the words in the proceedings. And then when it came to the authority that deals with the word in the proceedings, she responded by saying, but it doesn't relate to the Environmental Protection Act. Well, hang on, the first authority related to the Environmental Protection Act. You know, you've clearly got a full lock as far as I'm concerned, and it's a silly argument and should be rapidly dealt with it on that basis. There are, as I say, at paragraph 96, there's these arguments around grade A fee earners being briefed and expert counsel being briefed. And again, the more recent authority from Fordham helps in that case. He recognises that it's likely to be reasonable for prosecutors to instruct expert high-grade lawyers when facing a deep-pocketed defendant who's instructing very expensive lawyers themselves. And this can be helpful, particularly in cases when they see your cost schedule. Sometimes defendants will put in equivalently large cost schedules and then object about your cost schedule. Well, hang on. Or the alternative is they don't put any cost schedule and say, well, we're not happy that they're briefing counsel of 10 years call, to which it's not uncommon for the bench to query, well, what's your call to the person who's opposing? And invariably it's the same, if not higher. And a really helpful authority is the case of Felwell, where the Lord Chief Justice at the time observed that it's a welcome feature of these cases that the courts often make substantial orders against defendants for the recovery of investigative costs and costs that might have to be incurred to ensure equality of arms before a trial judge. So you should get well paid. And then finally, in relation to costs, risks for you and your client, it's only if there's a wasted cost order threshold made, which is quite a hard threshold for them to get over, that you should be subject to any costs. Of course, be aware you're pursuing a criminal prosecution, you have broader duties and obligations, but provided you meet those, you shouldn't be subject to cost awards against yourself. Equally, the CFA should not have a success fee in it. If it does, then it's then it's going to be found unlawful, and that could be a basis for challenging your cost order. And then finally, very quickly, if the landlord fails to then comply with the order that's made, you can then bring them back and enforce against them. And the most significant part about that is that if they are convicted on that, which is a lot easier to prove because it's just proving that they didn't comply with the order, you don't need to keep on getting the expert back for trial. It's just that a month later they hadn't done the work. If they're found guilty on that, then they do end up getting hit with a fine, and an ongoing fine of £50 per day. So that really will turn the screws on a landlord to make sure they get the case done. I have to say, this is exceptionally rare. In my years of practice, I've not seen a landlord fail to act once the order's been made, apart from in one case. And it was a very expensive day for that landlord when they did. The courts were not happy at all. I'm just getting notes from somebody on my thing. I've put £50 per day in I said £50 per day just now. I think I was looking this up just before. It may be £500 per day. I couldn't work out how in the past I thought it was £500 per day, but in my haste to be ready for the seminar, I hadn't quite pinned down where I'd got that figure from. It may have been that I'd missed. No, hang on. It is. No, it is. It is £500 a day, because that's 1/10 of £5,000, isn't it? Sorry, my maths was wrong this afternoon before I came in. So it's not £50 a day, it's £500 a day. That's right, isn't it, Phil? Am I right? My maths? 1/10 of 5,000? Yeah. Thanks for the commentary from my instructing solicitor who brought that to my attention separate there. But there we go. So yeah, £500 a day. So it really does turn the screws. Clearly, that in that scenario, a landlord's going to be quite keen to settle and get things resolved quite quickly. The defendant does have a right of appeal, as is standard in the magistrates' court. They can go and have a rehearing in the Crown Court, but the relevant date for that appeal will be the date when the trial happened in the magistrates' court. So you wouldn't need to get the expert to go back to the property again in the Crown Court. You'd still rely on the same evidence you had below. Though used to be in the old lag book, it used to say that the prosecutor also had an equivalent right of appeal to a rehearing. That since I don't know where that came from, and my paragraph 102 deals with why I think that's wrong, and actually it's disappeared from the more recent lag book on housing conditions. So I think that was just an error in the old lag book. And obviously all parties have the right to pursue case stated or judicial review. And there we go. Equally, the local authority does have powers under the EPA. You may want to get them to go in initially just to get an environmental health officer to give you a report on the cheap. Because if you get an environmental health officer's report that there's a statutory nuisance, even if the local authority don't prosecute, you could potentially rely on that to lay in information, provided you act promptly. But there you go. Anyway, I've run over by 15 minutes. Apologies for that. Are there any more questions? Okay, I don't think so. If there are any more questions, please put them in the chat or in the questions and answer section. There is a feedback form which we would be really grateful if you filled out, but I don't have the link immediately to hand, which is quite annoying. Phil, I don't suppose you have the link to hand?
I'm afraid I don't. I mean, if people want to talk sort of using their voices, can we just enable everyone to talk if they want to?
I'm not sure I'm able to do that, but
okay. We're still floundering here. Well, anyway, I think it's going to have to be chat then, if anyone has any more things they want to talk about.
I mean, I can, if somebody puts up their hand, I can allow them to talk, so that is something. But yeah, it's looking like we are where we are. It may well be that we don't. I'm trying to get. Unfortunately, I closed down Teams because it grounded.
I think Natalie's just posted the
excellent. Thank you. Thanks, Natalie. That's really helpful. So yeah, if you see the form there, if you could, it would be really helpful for us to get the feedback. So and it's a very quick form. It's a kind of a tick box exercise. Shouldn't take more than a minute or so to do. If you could do that. Great. Now, oh, hang on. Yeah, we have to share it. Sorry, it's just been given to us by Natalie. I'll put it in the chat to everybody now. If you could just click on that and go and do that straight away, that would be really helpful. While the iron's hot, so to speak. We'd be very appreciative. You can tell us how terrible we are if you want to as well in there, and you can do it anonymously if you want to as well. I think. I don't know, but anyway, or you could pretend to be somebody else and be offensive. That's fine as well. Yeah, it looks like no further queries or questions, but
okay.
I can't see anything coming up.
No, nothing else coming up. Well,
thank you everybody for coming.
Thank you. For turning on. Okay. Well, should we go?
Yeah, I suppose.
We all just press leave.
You didn't have any questions, Phil, did you?
No, I don't have any questions. I find it very interesting, Michael.
All right. Good. Excellent. All right. Okay. Thank you ever so much, everybody. I hope you had a good afternoon and have a good evening, everybody.
Okay. Bye.
Bye-bye.